With the growing trend of unmarried couples, friends, parents and siblings jointly owning property, we often receive inquiries where one property owner wants to know whether they can sell the property and what they are likely to receive out of the proceeds of sale. This can either be as a result of a relationship breaking down or simply because one of the property owners wants to get the cash out of their investment. There are different procedures depending upon whether you're married, unmarried, cohabiting, or investing with friends and business partners. It also makes a difference whether you have children together. We have specialist solicitors in the family and real estate litigation teams who can deal with each of these scenarios, provide you with advice on your situation, and guide you through the court process. Today's question and answer session is going to focus solely on cohabiting couples and does not apply to investment properties, married couples, or civil partners. The beneficial interest in the property can be held as joint tenants or tenants in common. If the beneficial interest is held as tenants in common, then it means that each owner has a distinct share in the property, for example 50-50 or 60-40. This is documented in a declaration of trust, which is normally found in the transfer document. If the beneficial interest is held as joint tenants, then the court will assume that the property is held 50-50. If the beneficial interest is held as joint tenants, then your interest in the property would pass to the other owner if you were to die. You can sever a joint tenancy so that the beneficial interest is held as tenants in common. If your relationship is broken down, then you may want to consider severing the joint tenancy to protect your interest in the property. If there is an express provision in the transfer document or declaration of trust stating how the beneficial interest in the property is to be held by the owners of the property, then the parties will be bound by those terms unless they can establish that the declaration was invalid or incorrect, that there's been fraud, mistake or undue influence, or there's been a subsequent variation. Now this will be difficult, but in some cases may be possible, and we can provide you with advice on your position. Yes, you can apply to the court in this scenario. Applications are made under the Trust of Land and Appointment of Trustees Act 1996. The court has wide-ranging powers and can make an order that the property be sold, and it can make a declaration as to what each party's interest is in the property. In addition, the court can order that the parties account to each other out of their share of the equity to take into account any payments one party has made towards the property since the relationship broke down. Paying the mortgage and other household expenditure does not entitle you to a greater share of the equity. The share of equity is determined by the declaration of trust that you entered into, or, in the absence of a declaration of trust, the court assumes that it is held 50-50. You may be entitled to compensation for the money you have spent by way of an equitable account. This allows the court to make adjustments to the money received by each party out of the net proceeds of sale, even where the shares are fixed. Payments towards the mortgage, buildings insurance, or in some cases improvements to the property can be included in the equitable account. If you have excluded your ex-partner from the property, for example by changing the locks, then they may be entitled to ask you to pay for a rent for occupying the property, and may insist on this as a condition of your continued occupation of the property. This can also be taken into account as part of the equitable account. Mediation is often the first step to consider before applying to the court for an order. At a mediation, you and your ex-partner will meet with a trained mediator to see if you're able to reach an agreement between yourselves. We recognise that at times court proceedings may be the only viable step to take where it's not possible for an agreement to be reached between the parties, and we have a wealth of experience in obtaining child arrangement orders and advising in relation to child abduction and relocation. The first step will be for you to send all of the documentation over to us so that we can review it and advise you on your legal position and options. You'll then need to send a letter of claim to your ex-partner, setting out what your position is and what you are seeking. You'll need to give your ex-partner a reasonable period of time to respond to that letter. If your ex-partner does not respond to the letter or you're unhappy with the response, then you can issue a claim at court. Once the claim has been issued, your ex-partner will have to respond to it. The court will then provide the parties with a timetable leading to trial, which will include directions for the parties to exchange the documents in their control that relate to the claim, for them to prepare witness evidence to support their position, and for them to obtain valuation evidence to assist the court. The majority of matters do settle before trial, but we will encourage you to consider alternative methods to try to resolve your dispute, such as a mediation.